only happened here. That too is not the case, and you all know it. And why do you know it? Because this Ethics Commission and your ethics staff have answered this question in the past. And I'm going to go to those so that you know that this is not unique. This question has been asked and answered many times. In connection with the Public Health Trust, this Ethics Commission was asked a question by a private proposer whether or not they could communicate in writing with a selection committee. The answer was yes, you may, so long as you copy the clerk of the board. Not unique. Happened again in June 2013. The question was asked, can you communicate directly with selection committee members so long as you do it in writing? The answer was yes, you can, so long as you copy the clerk of the board. Somehow the professor, in his great testimony, placed on you the issue of what is gatekeeping. The ethics code is about transparency. The reason for the written communication and copying the clerk of the board is so the whole world knows what the communication is. There's no gatekeeping function in connection with the ethics code. He was mixing apples and oranges and trying to confuse this whole discussion. This is about transparency. Now, what happened in this particular case with respect to transparency? I've read the 7-page letter that was submitted by your executive director. Hidden in between the issues regarding the process were very clear statements over and over and over again. CH2M Hill did not violate the code of ethics. He must have said it 4 or 5 times. Then he said, only in a footnote, that CH2M Hill acted in good faith in this particular procurement.
Mr. Johnson, isn't there a question with respect to and we don't even have to sort of get into and I accept that is I accept the executive director's conclusion with respect to CH2M Hill for the purposes of my question. Even if I accept that, whatever took place at the Tier 1 discussion seemed to put CH2M Hill in a different position vis-a-vis ACOM than ACOM was to CH2M Hill in light of the fact that more material had been submitted at that time and seemingly those submissions were in fact discussed and information disclosed.
That's a very good question. Your question goes to the heart of why there's so much confusion here. After the Tier 1 is over, there's not, the scores don't go forward, the ranking is irrelevant, what is discussed is wholly irrelevant, and again, I provided that to you in the October 7th communication. When the staff began the Tier 2 meeting, and the county attorney's opinion was read to the selection committee, he said, and they said specifically, that what took place in Tier 1 is irrelevant. We have shortlisted...
But it wasn't irrelevant.
No,
right?
it is irrelevant.
CH2M Hill walked out of the Tier 1 meeting, arguably, with an advantage, given what might have been discussed and given what they might have been privy to.
If you believe that somehow the project approach, which is the only part of the Tier 2 discussion that we're talking about, was discussed as part of the Tier 1 meeting. That's only if you believe that to be the case. It not only wasn't discussed, it wasn't scored. It was not scored. And at the end of that Tier 1 meeting, the selection committee asked both teams to present their approach and present their materials at the Tier 2 meeting. It was asked, and then it was put in writing. Please be prepared at the Tier 2 meeting, this is after the Tier 1 occurred, to present your approach. What's also lost here is the role of the county attorney. The county attorney the Office of the County Attorney is the office that interprets most of the code. You have exclusive jurisdiction over the Ethics Code. The Office of the County Attorney issued an opinion that said that our decision to wait to the Tier 2 submittal, which had happened in all 20 of the prior 20 Water and Sewer Department procurements, was permissible even under this one. And their election to do it as part of the Tier 1 was their election. So what your question just asked me, if they make a strategic decision to try to influence the selection committee, and the fact of the matter is they did, and I'll go to the record on that, to influence the selection committee as part of the Tier 1 by submitting a project approach early, that's their choice. It is not our problem that they took that choice. They had that choice, they took it. We had the choice of doing it the way it had been done for all 20 of the past 20 solicitations, and that was submitted as part of the
But
Tier 2.
is that correct? If I heard what Mr. Grady was saying, he said the opposite.
He didn't say that. You need to ask this question. In notices to professional consultants issued by Miami-Dade Water and Sewer Department, which is precisely what this is, in how many of them was the approach presented as part of the Tier 1? That's the question. He did not say what I said. He did not say
Focus
that.
on the Miami-Dade Water and Sewer.
That's right. This is exactly what this is, and the type of procurement. It's not an RFP. It's not an invitation to bid, and that's why they keep mixing apples and oranges. That's why this is so different, and a separate administrative order has been issued to explain what happens between Tier 1 and Tier 2. Let me also explain what happened. You're getting the impression, somehow, that CH2M Hill held on to its approach, got a competitive advantage and listened, and then sprung it on the selection committee at the very last minute to try to gain a tactical advantage. But that didn't happen. What really happened? After the Tier 1, remember there was a very short window. We contacted the county attorney in writing, copied the board, very transparent. We have the information that you're asking for. We want to deliver it to the selection committee. We then get a letter back from the county attorney that says that the option that AECOM used to present its project approach as part of Tier 1 was permissible. You may submit your project approach as part of Tier 2. Within 24 hours of that letter, we submitted that information. It wasn't that we were holding it, trying to gain a competitive advantage, sprung it on the selection committee. It was within 24 hours of that letter that information was submitted. Also, what you haven't heard, go ahead and read I'm sure you've read the Office of Inspector General's report. That report says, oh my God, it was 400 pages. I didn't read it. I don't know what it says, but it sure looked pretty big, and therefore it must have been improper. Read the footnote in the Inspector General's report. Didn't even read it. So no one is even arguing that what we submitted was improper. In fact, the Office of the County Attorney, that has the right to determine whether something is timely, responsive, permitted, indicated that what we submitted was timely, proper, and responsive. There's absolutely nothing in this record, and in fact, every time we come before an official body, we're clear. Because what we submitted, how we submitted it, whether it was 400 pages or not, and it's important you put this in context. 200 pages of it was just telling the committee what we were going to do by quarter through 2027. See, the problem with not reading what's in it is to not understand why it had to be 400 pages. It sounds immense, and somehow there was some competitive advantage gained. But that is not the case. I also want to talk about this whole idea of the absurd result by the common sense approach that AECOM is suggesting that you take. And your staff attorney has already said it, but I want to put a finer point on this. It is not unusual for municipalities or county government to reach out to people in the community to have them sit on selection committees. It happened with the Miami Beach Convention Center selection committee. All outsiders, no staff. It happened in connection with a procurement that related to the procuring of Metro Rail cars. In fact, there was a staff member who was a staff member during the first part of the selection process. Then he left the county and came back and participated. To go to the point where only those selection committee members who are staff can be communicated with in writing, and those who are not can't be because of the common sense approach that AECOM is suggesting to you, causes confusion, is utterly ridiculous. And talk about a process where you have some committee members that have some information and other committee members who have other information. Either they are performing a government function, which they are by law, and absolutely that is the case, and they all are required to receive in writing any communication, or they are not. The other reason why that's important is because there are all kinds of communications that bidders can give. And at the end of the day, the Ethics Commission should be concerned about transparency. You want us to register as lobbyists not because you're the gatekeeper of lobbying, it's because you want transparency. Who represents whom? You're not looking for copies to the clerk of the board because there's a gatekeeping function. It's because it's transparency. Who has submitted what to whom? This is about transparency at the end of the day. And what did let's talk about the facts in this case. CH2M Hill asked in writing what it could do, copied the clerk. The whole world had notice of what we asked. Received an answer back in writing. The whole world knew what the answer was. We submitted our project approach as part of Tier 2 and copied the clerk first. In fact, my client went to the point of having somebody at the clerk's office at that moment to make sure that nothing got delivered until after the clerk and again, this is where the IG just misses the point, first page, bottom of the page, she creates these facts that somehow we didn't copy the chief procurement officer. And there's this loophole that's created. In this case, the chief procurement officer was actually copied. So these facts that are being thrown out here completely miss the case. So transparency occurred. Good faith has been acknowledged by your executive director. We asked and got answers in writing. Everything was at the clerk of the board for the whole world to know. It could not have been more transparent. And it could not have been more in accordance with the law. My last point, and then I will conclude. When you have a proposer who wins by following the precedent of this Ethics Commission that has said on countless times before that what was done was proper, and there's not a single allegation of what we submitted was improper, the content of it. There's not a single allegation of that, not one. There's not one allegation that we somehow were trying to gain a competitive advantage. We simply waited for an answer and responded. So now you have a company in this very important procurement who follows all the rules. The county attorney has said we followed the rules. The county staff has said we followed the rules. Your executive director has said we followed the rules. And now, because of the theory of the possibility of something could happen, there's now a problem. And that is just not the case. Thank you. And I'm available to answer any questions.
Thank you. I simply want to correct the record. I don't think the Inspector General said you hadn't. She said the statute theoretically could allow the bypassing of the procurement.
Yeah, but you're correct. In the first page, at the very bottom, I think it's the last line, she says that one of the loopholes is that the chief procurement officer could be bypassed. And the whole discussion about gatekeeping went to that. And I want you, and the clarity I wanted to bring to this, in this case, we actually did copy the chief procurement officer.
But she didn't accuse you of not. That's all.
We've
I just
been
wanted to-
accused of a lot, but never found guilty of anything. Thank you very much.
Brief 1 minute rebuttal.
One question I have
Sure.
is, in terms of the process, as Mr. Dotson described it, he said this wasn't an RFP process. Tell me about that. How is it that, I mean, you made a statement earlier, at least my interpretation was that there were, this has never happened, that they took a very unique approach to this. And I'm just kind of
That is correct.
wondering, what's that basis and
I
what
have
Mr.
a
Dotson said, whether it's correct or not.
Sure, I have a fundamental disagreement with my colleague. And by the way, I want to make clear that when I'm talking about what counsel for CH2ML did, it wasn't Mr. Dodson that was counsel at that time. But I have a fundamental disagreement with my colleague on that point, because the case law is very clear that procurements may be different and may have different methodologies. An ITB goes only on price. An RFP is a combination of price and approach. An NTPC is only about qualifications and project approach, but the case law is clear that all of them must be run by a set of rules, and that those rules must be followed in order for the process to be deemed to be correct. And so,
But you heard him. He said that on these Metro Dade Water and Sewer projects, there have been 20 of them, that he's followed down the line a very similar approach.
and
Is
that
that correct or not?
No, and that makes my point, because number one, he has not brought to you the 20 solicitation documents, and the case law is very clear that everything is dependent on what the solicitation document says. It actually makes our case, because those solicitation documents specifically request a Tier 2 submission. Our point is, when the process wants to request, it puts it in writing. When there is no request for Tier 2, there is only one submission deadline, as in 1.7, and an admonition that any late proposal will give a proposer a competitive
Can you
advantage.
stop there, because I see the executive director was nodding his head. Do you agree with that?
I just wanted to, I think I can help with the question, and that is in terms of whether it's unprecedented or not, because I've spoken to the county staff extensively about this, and what was unprecedented here was the breadth, the scope, the size of the submission. The county staff has told me clearly that they've never seen that before. Now, have there been occasions when perhaps there have been some communications, much more limited communications? I expect there have been. I know that my predecessor gave an opinion, an informal opinion, that it was permissible. We've had that question asked a couple times, so I believe there probably have been situations when there has been some submission, perhaps it was invited or asked for, I don't know, but there's never been anything on the scope of this. That's really what made this unique, as far as I can tell from the staff.
But reading Patra Lou's letter, right? She says AO 339 says, right, and so she reads the second tier passage. It says, on its face, the passage indicates that the submission of supplemental information is not only permissible, but is a standard practice. And then she talks about the wording of section 2.2. And I guess I'm not having the full document in front of me. What's the relationship between AO 339 and section 2.2 of the notice to professional consultants? Because, right, on some level, if AO 339 is the default around which any particular notice to professional consultants can contract, or from which it can deviate, then yes, we recognize that AO 339 could be superseded. But I'm unclear as to the relationship. She seems to suggest that there is some real confusion here with respect to what governs and what that means with respect to what could have been submitted at a second tier.
Mr. Chairman, may I answer that question
Let me-
directly?
Well,
After Mr. Grant?
Absolutely.
Yeah, let me take you to that point. The solicitation document says AO 3-39 is applicable. AO 3-29 on its face says it is advisory only and can be superseded by the solicitation
39
documents.
or 29? You just said 20.
I believe it was 39. So now you need to look at what the solicitation document says. In Mr. Dotson's entire presentation, there's one argument that he has not addressed, which is key, And again, we're talking about broader issues, but the narrow issue here is, can you communicate a submission directly to selection committee members? What Mr. Dotson did not.
But let me say, the heading of 2.2 says, submittal requirements for initial submission and second tier additional information when applicable. So at least in the heading of 2.2, even if we get to the point of one deadline, there seems to be the suggestion, even in 2.2, that there will be a second tier process at which additional information would be submitted.
It says, when applicable. There is nothing in the solicitation document that tells you that it is applicable. That basically is standard language that you put in every heading of every solicitation. Now,
Does it tell you that it's not?
it doesn't tell you that it's not,
It doesn't tell
but
one way or the other.
But then you are enlightened by what occurs in the process.
So why doesn't the email that CH2M Hill sends to the selection committee on August 9 trigger the applicability of that condition, even if I accept that your interpretation that that language is conditional and will be triggered when applicable? Why doesn't CH2M Hill's email on August 9, 2013 to the selection committee saying, this is how we will proceed, trigger the conditional applicability of these additional submissions?
Because it's not up to the proposer to determine how it will proceed, it's up to the county. The procurement officer makes very clear after tier 1, and it's on the tape, she asked the selection committee members, is there anything you would like to hear for tier 2? One of the committee members says, project approach. And so Ms. Samuels says, we will ask the proposers to include project approach as part of their presentation, not as an independent submission directly to selection committee members. When 2 days before the selection committee, the county attorney writes to Ms. Samuels and inquires, is there anything that is due, and if so, at what time? And Ms. Daniels responds, there is no additional submission due for tier 2, they are only to include project approach in their presentation. So here, to give you an example, and then I'll touch on the point that Mr. Dotson did not touch upon, this is equivalent to, at the end of a jury trial, which is our case in chief has been presented, that would be our submittals. At the end of the jury trial, a judge would say, okay, here's what we're going to do. We're going to go to closings, and each party has 45 minutes. But before that, I'm going to allow Mr. DeGrande to file a 500-page brief. I am going to give that directly to the jury without reviewing it myself. I'm going to allow them to take it overnight and review it, and then both parties are going to have 45 minutes. That is totally...
So your argument is that the interpretation should have been, you don't submit 400 pages or whatever, it didn't matter. Obviously, it was a lot of pages, and Mr. Johnson's explained it. So you're saying the competitive advantage here was that instead of using it in the presentation, they actually submitted.
Of course, that was the competitive advantage issue, but now the narrow issue of the cone of silence, which is what you're dealing with, what Mr. Dotson did not cover is section 1.13. Now, how do you do the analysis on section required by section 1.13, which creates a uniform methodology for vetting proposals unless there is a specific prohibition on direct delivery to selection committee members? You cannot accomplish it. There is no way to accomplish it, because once you give it to selection committee members, if there was information there that they should not be considered, the damage has already been done. So there is absolutely...
Well, but as I read 1.13, that is to say, the risk is borne by the entity who submits. That is to say, if you submit information that is that you would at some point want to hold out as confidential, or want to protect rather as confidential, i.e. a trade secret or other confidential, and then the submission says, it says, the submission of any information to the county in connection with this solicitation shall be deemed conclusively to be a waiver of any trade secret. And so my reading of that is that the entity doing the submission bears the risk of the consequences of submitting information that they later might attempt to protect as confidential.
No, there's two different parts of that that have two different implications. The part that says it will be deemed conclusively to be a waiver of trade secrets has to deal with public records law. And what that's telling you is, if you submit that, you submit it at your peril, and if your competitor now makes a public records request, you are deemed to have waived it. But then it goes on to say that the submission will be reviewed and that information will be redacted. So the whole purpose of 1.13 is to create a uniform methodology for review that requires staff to review, to vet, and to redact prior to the selection committee being exposed to the information. If the selection committee is exposed to the information, which it could not consider as a matter of the explicit terms of the solicitation document, the damage is done. The process has been vitiated and must start all over because they have considered information which is inappropriate. I gave you an
Could they have
example.
presented it verbally though, orally, before the selection committee, in your opinion?
If they would present information that they say, look, this is trade secret and confidential, but I would assume that the procurement officer would stop them and say, you cannot present that information. Just as if they present any other inadequate or inappropriate information, they would be stopped in the middle of a presentation, told you cannot present that information. The rules tell you that you cannot present that
Do you
information.
take any issue with the 400 pages? And I know it doesn't make that much of a difference one way or another personally. Does it matter to you that it was 400 pages?
Absolutely,
He's
because
explained
what
it
it
well.
was basically was a whole new proposal. And a whole new proposal after they had the opportunity to have reviewed our proposal and after they had the opportunity to hear the critique on Tier 1. And by the way, Mr. Centurino will confirm, you know, Mr. Dotson continues to insist that Project Approach was not part of Tier 1. Mr. Centurino will confirm that staff explicitly states that Project Approach is to be submitted before the Tier 1 presentation. And
But
so,
it included the process within there, right? Which is what the selection committee wanted in Tier 2.
excuse me?
It included the process within the 400 pages.
It included Project Approach, but it also included stuff that was supposed to have been in Tier 1. Additional experts, additional statements of qualifications, etc. So it went way beyond a narrow
And I've read
Project
your
Approach.
papers, and I fully understand that argument. I just want to analogize, in terms of a jury trial, we all know if you're an attorney who practices in federal court, you know there are limitations as to pages. But if those limitations weren't there, what happens?
You write a book.
It's a free-for-all, right? That's
Exactly.
usually what attorneys want to do,
Exactly.
right?
That's why you limit to 45 minutes per side to make it equal for both sides, and it's an oral presentation only, not a submission, and certainly going to the point of the proponent of silence, not a submission direct to selection committee members, because if so, 1.13 cannot be implemented. And that's what makes clear that there has to be that
But
exclusive
again,
conduct.
I'm not clear that 1.13 is, and the part of 1.13 that you seem to focus on seems to simply be a safe harbor. That is to say, it says if you identify the information as protected, then the county shall endeavor to redact. But it seems to me if I submit to you everything, identifying nothing as private, right? Then I have and then I am willing to take the risk that whatever has been submitted, the confidentiality of this information has been waived. The only dilemma, it seems to me, that is presented to the submitting party is that if you mark too much information as private, then you run the risk that the proposal is non-responsive. I don't understand 1.13 to mean that there is material that can't be submitted. That is to say that material is submitted at your peril.
Correct. It is submitted at your peril for public records purposes. However, clearly 1.13 says there is a methodology by which every submission would be
But
vetted.
that's really a kind of that's kind of a safe harbor provision, it seems to me. That is to say, again, if a submitter is willing to bear the risk,
For public
the
records.
county says, look, if you're not, then indicate what's private, we'll redact it. We're giving you an assurance of that. If you don't, you waive it. And so I'm not clear what regulatory regime 1.13 creates that I, as a submitter, cannot say, I don't want to participate. I'm willing to take my risk by.
There is a uniform vetting process that is set forth in 1.13. It is not the proposer's decision to decide what is appropriate for a committee to review or not. It is only the providence of staff, and that creates that uniform methodology.
Again, the only role that the county plays is, it seems to me, the role of redacting that which is. It says, if a proposer submits information to the county in violation of this restriction, either inadvertently or intentionally, and clearly identifies that information in the proposal as protected or confidential, then the county shall endeavor to redact and return subject information to the proposer as quickly as possible, if appropriate. So it all depends upon what the submitter does.
Correct.
And so I don't understand the interpretation that seems to suggest that there is an independent, non-conditional role for county officials to do this vetting.
There is, because the next sentence tells you that there will be a subsequent review of the redacted portion to determine whether it is responsive. A responsiveness review occurs before the submissions are given to selection committee members. So in effect, 1.13 creates a uniform methodology for vetting submittals that must be conducted prior to the evaluation committee receiving the proposals. And the point is that to do otherwise shifts to the proposer as opposed to staff to determine what is appropriate for the committee to review or not review. Now, obviously, what that section is telling you is, look, if you present confidential information, and here we have a question as to whether this was confidential information or not. If you present confidential information, number one, you do so at your peril from a public records perspective. We can now give that to anyone. But the second thing we will do with every proposal, before it can be seen by selection committee members, is conduct our review. We will make the determination of what will be redacted so that the committee is not exposed to information which it cannot consider. That is a uniform methodology of vetting the proposals, and the responsiveness review then occurs subsequent if there is a redaction, and every responsiveness review must occur before the submissions are sent to the selection committee. So clearly it creates, whether in any specific case, and the question here is whether this applied for this proprietary information, but let's assume it didn't. Let's assume that the entire CH2 M Hill proposal did not have confidential information. It does not vitiate the fact that there is a process, that is a required process, and that by issuing the proposals directly to the selection committee, you bypass that process, you bypass the gatekeeper that has to necessarily do that review, and you decide, as opposed to the county,
Is there
what can
any
be seen.
reason other than confidentiality that selection committee members can't review the submission?
Oh, there are many things that staff may choose to redact. For example, the argument made by counsel for CH2M Hill in his letter of August 22. He was arguing that as far as our submission, the information regarding project approach should have been redacted for Tier 1, and that it was inappropriate for the selection committee to have reviewed that information. So they knew there was a vetting process, and they knew that it was a uniform process. Not only confidential information is specifically addressed there, but there are many other things that staff may consider this is wholly inappropriate, this is scandalous, this is irrelevant, this is inappropriate, and they will endeavor to redact it. There is a uniform process. That is the point. Before it ever gets to selection committee members, that was bypassed here by direct delivery of the submissions.
I'm of the opinion that that's an overreading of what 1.13 says, confidential information. That is to say that it seems to me that whatever the regulatory regime here is, it is a regulatory regime that is about the protection as best as possible of confidential information that might in fact be waived by a submitter.
But it also says that that information will be redacted And the only purpose of that is so that it cannot be considered by the selection committee. And I agree with you, 1.13 deals only with 1.13. My point was, counsel for CH2M Health seems to agree that there are other things that could be taken out and that there is a uniform methodology for vetting these proposals prior to the selection committee being exposed to the information.
Judge Wu.
I just wanted to say, it seems to me that you and Mr. DeGrande are going to be debating this issue back and forth, sentence for sentence. And I think we really need to get moving at this point.
Happy to do that.
Thank you.
In light of those words, I'll be brief. First of all, I mentioned to you 2 prior decisions by the Ethics Commission on this very issue. You would think that the NTPC in 1.13 and Section 2 that you've been referring to is somehow unique. But in both of the 2 cases where you authorized direct communication to selection committee members, these same provisions were in those solicitations too. One had to do with the Public Health Trust and one with the City of South Miami. So there's nothing unique in that regard. Second, you're absolutely right that anybody who submits anything to selection committee members directly, as legal as it may be, they do it at their peril for 2 reasons. One is on confidentiality, which you've raised, and the second is on responsiveness. Have you submitted something that now deems you non-responsive? You should ask the question, has the county attorney, whether it was 400 pages or 10 billion pages, have they determined that we are now non-responsive because we submitted information that should not be submitted? You can ask the question, but allow me to answer it. Of course they have not. So all this theory about submitting stuff that should be redacted is not true in this case for certain, because the county attorney has not determined that anything we submitted was non-responsive to the NTPC. Lastly, with respect to competitive advantage, and then I'm gonna just close with the 20 former WASA procurement, so you know specifically what they are. It's in a normal bid protest, the arbiters would have copies of the solicitation. You'd have copies of the responses. You wouldn't just hear oral argument from the 2 parties to tell you what was in it and what wasn't, whether or not there was a competitive advantage or not. It's unfortunate that we now find ourselves with a disgruntled bidder that lost, putting you in the position of making decisions without all of the information. On the ethics issue, I think it's clear, and the staff attorney has it right. It's been your position all along. But it's important for me to, again, validate, because you asked Mr. DeGrande the question he did not answer about the past 20. I have a list of all 20 of them. I could read them for the record just so you have it. You can defer decision if it's very important. I would not represent to this group that the past 20 NTPCs were handled precisely the way our client did. It was the design services for the major gravity inceptor issued by Miami-Dade Water and Sewer Department. Upgrades to the sanitary sewer pump stations. Design of the 36-inch water
With due
main.
respect, I think we'll take them in written form.
Okay, then we'll be happy to submit all 20 that reflect that this process is not unique.
Thank you. So do we have comments with respect to the our memorandum, the memorandum of commission staff? Questions or suggestions before we proceed? I suspect I would simply add to the memorandum the issue of the relationship between the selection committee's recommendations and the mayor's ultimate decision-making authority. That is, does the mayor have to explain departures from recommendations made by the committee? Does the mayor possess the authority to simply ignore? And I assume, because I think that's an important question with respect to their exercise of authority. So I'm comfortable with the conclusion that certainly if the mayor has to explain this, and if this forms the basis of some official record, then this is not insignificant exercise of government with respect to question one.
The only thing I would add to that regarding the definition of official, I do have a concern about liability, because I can't see how that can impact the citizens of this county. So again, it doesn't have to do with my official position, but certainly a point of inquiry that I think should be looked into.
So do we have a motion?
I would just suggest that since there are two questions raised in the memo, and I think they're very narrow legal questions, that perhaps the commission should address each one separately and take a separate vote on
A separate vote on it? Okay. So, do we have a motion with respect to question one?
Move to approve question one. The response to question one.
Do we have a second?
Wait, can I ask a question? Didn't we just ask Mr. Dotson to provide the 20 memos from water and sewer? So how are we going to vote on something if we've asked him to submit something in writing to review it?
Question one is that submission of the
Okay.
Do we have a second?
Second.
We have a motion and a second. All in favor of the recommended answer to the question, is a member of a county selection committee an official for purposes of the cone of silence ordinance as to be amended by some of the questions or suggestions articulated here, and say aye. Aye. Any opposed? Opposed? I suspect we will wait for further factual development, at least the issue of question two, so that we might gain a little more perspective with respect to the particulars of the notice to professional consultants and the tier 1, tier 2 process, particularly the question of the submission of additional information at the tier 2 process. So my sense is we will hold that